Welcome to the deep dive. Today, we're looking into something pretty shocking, legally speaking. Sometimes, how a doctor fills out a billing form can actually matter more than a daughter's desperate, heartfelt promise to save her father. The challenge we're tackling is this: enforcing an oral promise, one made in the heat of the moment, to pay for emergency medical care for someone else. How does the statute of frauds deal with that? Especially when the promise sounds direct, but the paperwork, well, it seems to point elsewhere.
That's exactly the core issue. We're going deep into the suretyship provision of the statute of frauds. It's all about understanding the difference between what's called a primary obligation, your own debt, basically, which is okay if it's oral, and a collateral one. A collateral obligation is more like a backup promise guaranteeing someone else's debt, and that usually needs to be in writing. And the whole thing, surprisingly, often comes down to this one tricky detail. Who did the creditor, like the doctor in your example, actually give credit to on paper? It sounds counterintuitive, I know.
Okay, before we dive headfirst into the statute of frauds, let's set the baseline. If you call a doctor, say, for a family member who's had an accident, are you automatically on the hook for the bill just because you made that call?
Generally, no. The basic rule is pretty straightforward. Just calling a professional to help someone else doesn't automatically make you liable for the cost. Now, there are exceptions. Like, if you're legally obligated to provide that care, maybe you're a guardian. Or if there's a really clear express agreement where you say, I will pay. Or, if the situation makes it obvious both sides intended for you to pay. But without one of those, the liability, it stays with the person who actually received the service, the patient.
Right, that distinction is key. But what if there is an express agreement? Someone says, I'll pay. When does the statute of frauds jump in and say, nope, need that in writing?
It jumps in when the promise is collateral, meaning it's really a promise to cover someone else's debt. If your promise makes the debt entirely your own right from the start, that's primary, it's original, then the statute of frauds doesn't apply. The real test, you ask, does the original person, the patient, still owe the money after this new promise is made? If yes, then the new promise is just a backup, it's collateral, and it needs to be written down.
And that's the friction point, isn't it? The words might sound primary, like I'll pay, but the legal effect ends up being secondary, collateral. Let's unpack that with a case. Lawrence v. Anderson sounds like the classic example here. First, can you lay out the key facts for us? What actually happened?
Sure. So you have Dr. Lawrence, the plaintiff. He treats John Anderson after a really bad car accident. Anderson's daughter, the defendant, she's right there at the scene. And according to a witness, she tells the doctor, I want my father taken care of and give him the best care you can give him. And what the charges are, I will pay for it. Sounds pretty direct, right?
Absolutely. Sounds like she's taking it on herself.
Exactly. But, and this is the crucial part, later on, Dr. Lawrence actually makes out the original bill to Mr. Anderson, the father, the patient. He sends bills to Anderson's estate for collection, and then later even to his widow. It was only after those attempts didn't work out, something like a year and a half later, that the doctor turned around and sued the daughter based on her original statement at the scene.
Wow, okay. That billing history feels really significant.
Yeah.
So, what was the core legal issue the court had to sort out?
The central question was this. Did the doctor's actions, specifically billing the father first and essentially extending credit to him, cancel out the primary nature of the daughter's spoken promise? Did his paperwork turn her seemingly direct promise into a collateral one, putting it under the statute of frauds?
So you have this conflict, spoken words versus written records. What rule did the court use to decide which one controlled? What's the black letter law here?
The court used the suretyship rule, but with a very important condition attached. The basic rule is a promise is primary, meaning outside the statute of frauds, if the person making the promise makes the debt their own, their sole obligation. However, and this is the Lawrence twist, if the creditor, the doctor here, extends any credit at all to the original debtor, the patient, then the law considers that creditor to have chosen to treat the spoken promise as secondary, as collateral. And if it's collateral, it needs to be in writing to be enforced. So this gives us a two-step test for these situations. One, first, was the defendant's promise actually primary and direct in its wording, in form? Two, and second, crucially, did the plaintiff, the creditor, extend any credit to the third party, the original debtor?
Hold on. Are you saying that in the middle of an emergency, a doctor is supposed to figure out if the father is being legally let off the hook for the debt just so the daughter's promise counts as primary? That seems almost impossible in that kind of situation.
That's the tough implication, yes. For the daughter's promise to stand alone, outside the statute of frauds, the doctor essentially had to treat her, and only her, as the one responsible for the bill from the get-go, which logically means the father's liability would have had to disappear at that moment.
Okay. Thank you for clarifying that. Let's move to the court's elemental analysis. Step by step. How did they handle that first element? Was the daughter's promise primary and direct in form?
Right. The court looked squarely at her words. What the charges are, I will pay for it. They concluded that, yes, linguistically that is a direct promise, so in form, the promise looked primary. If that was the only test, the statute of frauds wouldn't have been an issue here. Element 1, check.
Understood. But clearly that wasn't the end of it. The case really turned on the next part. So what about the second element? Did the plaintiff, Dr. Lawrence, extend any credit to the third party, Mr. Anderson?
This was the nail in the coffin for the doctor's claim. The court pointed out that the doctor could have put everything solely on the daughter's credit right away. But he didn't. The evidence was clear. He made the original charges out to Mr. Anderson. He sent bills to Anderson's estate. That conduct, the court said, was basically conclusive proof that the doctor did give credit to the original patient. The reasoning was you can't really hold both liable independently on just an oral promise like this. By getting credit to the father, the doctor effectively elected to treat the daughter's promise as a backup, as collateral to the father's debt.
That feels incredibly strict. What about the fact the doctor never explained why he billed the father first? Maybe it was just, I don't know, standard procedure. Did the court consider that? It seems like a simple administrative choice sunk a promise made in good faith during a crisis.
It is strict, and it shows how powerful that administrative step is. The court acknowledged that charging the third person first could potentially be explained away, but, they said, you'd need really strong evidence to counter that assumption. Since Dr. Lawrence didn't offer any explanation for why the bills went to Anderson first, the court basically had to assume he viewed Anderson as the one primarily responsible. And boom, that makes the daughter's promise secondary, collateral.
And bringing it all together, after looking at both elements, what was the court's final conclusion?
They affirmed the judgment for the defendant, the daughter. Because the doctor's own actions, his bookkeeping showed he extended credit to the father, the daughter's oral promise was legally classified as collateral. And since it was a collateral promise not in writing, the statute of frauds made it unenforceable. The court specifically mentioned the doctor couldn't just decide later to make it a joint obligation without the daughter agreeing to that explicitly.
That verdict really drives home a stark point. The paperwork can override the spoken promise. Let's try a visceral hypothetical to really cement this rule for everyone listening. Okay, imagine this. You're at a fancy butcher shop. Your friend spots an incredibly expensive rare cut of Wagyu beef. But oh no, he forgot his wallet. You step up, loud and clear, tell the butcher, "Give him the beef, I guarantee it. I will pay the bill personally." The butcher smiles, hands the amazing steak to your friend, but then prints the receipt and enters the charge in his ledger under your friend's name. If your friend vanishes, can that butcher come after you based on your very clear, very personal oral promise?
Nope. The butcher is out of luck enforcing that promise against you. Even though your words, "I will pay personally," sound completely primary, the butcher's action recording the debt against your friend is the deciding factor. That act demonstrates he extended credit to the friend, the third party. And just like in Lawrence, that converts your primary-sounding oral promise into a collateral one. Since it wasn't written down, the statute of frauds blocks enforcement against you. For the butcher to have held you liable, that ledger entry needed to show the debt was yours, and only yours, from the very beginning. Okay, so if you're facing a potential suretyship issue, maybe on an exam or just trying to understand this, here's how you should break it down. Think of it as a 4-step checklist, pulling together what we learned, especially from Lawrence. Step 1, identify the promise. Simple enough. Is someone promising to pay for stuff, goods, services that someone else is receiving? Step 2, primary versus collateral. In form, look at the words used. Was it direct, like "I will pay"? Or was it conditional, like "if he doesn't pay, then I will"? If it's conditional, game over, it's collateral. Needs a writing, SOF applies. Step 3, and this is the big one from Lawrence, analyze credit extension. This is the Lawrence test. If the words sounded primary from step 2, you immediately have to ask, did the creditor, the person owed the money, give any credit to the third party, the person who got the goods or services? You look for the hard evidence. Who got the first bill? Whose name is on the original charge in the books? Who were they trying to collect from initially? And finally, step 4, conclude. If the answer to step 3 is yes, if the creditor gave any credit to that third party, then the oral promise is automatically treated as collateral. It falls smack within the statute of frauds and is unenforceable unless maybe there's some incredibly strong reason offered to explain away that billing record.
So wrapping this up, the big takeaway seems to be, well, it's kind of sobering. Legal reality in these situations isn't always shaped by the urgent, emotional words spoken, but by the cold, hard facts of bookkeeping afterwards. The second the creditor tries to cover their bases by keeping the original debtor listed, even just internally, they've potentially undermined the enforceability of that verbal guarantee, pushing it into the territory where it needs to be written. It really is a case of the process potentially trumping the promise itself.
Absolutely. And this leaves us with a really practical question for you to think about. Remember, the court said the doctor couldn't just make the daughter's promise a joint obligation without her agreement. So what specific words could the doctor have used right there at the accident scene to make absolutely sure the daughter was the only one on the hook, legally speaking? Think about what has to happen to the father's debt at that exact moment for her promise to be truly primary and escape the statute of frauds.